Welcome to the Cod Fisheries Debate of 1792 class by the Grumpy Old Vet. This is Lesson 20 in this series. This lesson will cover an argument that James Madison made on the floor of Congress in counter to Alexander Hamilton's argument that the phrase, "for the general welfare," in Article 1, Section 8, Clause 1 of the Constitution, gave additional power to Congress to collect money and do what they deemed was for the general welfare of the country. Madison's speech mirrors concepts that he wrote in Federalist Paper 41. With that, let's move out. Welcome to the class, Cod Fisheries Debate of 1792, brought to you by the Hillsdale Justice Project at Liberty Hall, narrated by John Rutan. On 3rd February 1792, the Committee of the Whole began consideration of the bill for encouragement of the cod fisheries. As passed by the Senate, the first section of the bill replaced the existing drawback of the import duty on salt to exporters of salted fish with a new one based on tonnage to owners of fishing vessels. Debate on 6th of February centered on the advantage which the bill bestowed on New England and stressed the importance of the fisheries as a source of trained sailors in case of war. The very first tariff, enacted in 1789, contained a provision for payments to exporters of dried and pickled fish. However, the real furor over bounties did not erupt until early 1792, when Congress debated a law that repealed the 1789 payments and replaced it with direct payments to cod fishermen and their crews. The Senate bill proposed to repeal the 1789 system of payments and provided for paying to the owners of vessels employed in the cod fisheries a bounty based upon the size of their boats and the quantity of fish they landed, to be divided among all their crew. This debate was a culmination of divided feelings stemming from Hamilton's report on manufactures. Hamilton's famous report on the subject of manufactures has cast a long shadow over U.S. trade policy toward industry. Issued in December 1791, the report not only provided theoretical justifications for the promotion of domestic manufacturing, but as a policy document made specific proposals for government action. These proposals included higher import duties on certain final goods, lower import duties on certain raw materials, pecuniary bounties, production subsidies for selected industries, and government assistance for the immigration of skilled workers, among other measures. To this day, the report is often heralded as the quintessential American statement against the laissez-faire doctrine of free trade and for activist government policies, including protectionist tariffs, to promote industrialization. Alexander Hamilton's Report on Manufactures, 1791, is a classic document of U.S. economic policy, but its fate in Congress is not well known. It is commonly believed that the report was never implemented. Although Hamilton's proposals for bounties, subsidies, failed to receive support, virtually every tariff recommendation was adopted by Congress in early 1792. These tariffs were not highly protectionist because Hamilton feared discouraging imports, which were the critical tax base on which he planned to fund the public debt. As a consequence, protectionist interests shifted their political support from the Federalists to the Jeffersonian Republicans during the 1790s. Congress apparently tabled Hamilton's report after receiving it, with no clear indication of when it would be taken up for debate. Whenever that debate was to take place, however, James Madison, in the House, and Thomas Jefferson, in the Cabinet, were preparing to fight it. Madison and Jefferson believed that bounties were unconstitutional and, if enacted, would set a dangerous precedent. Hamilton anticipated this objection in the report, noting that Congress had the express authority under the Constitution to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare. In Hamilton's view, the phrase general welfare was as comprehensive as any that could have been used and necessarily embraces a vast variety of particulars. Therefore, it was of necessity left to the discretion of the national legislature to pronounce upon the objects which concern the general welfare, and for which under that description an appropriation of money is requisite and proper. Madison contested this interpretation, as he wrote to a colleague in January 1792, less than a month after the report was issued. What do you think of the commentary, pages 36 and 37, on the terms general welfare? The federal government has been hitherto limited to the specified powers by the greatest champions for latitude in expounding those powers. If not only the means, but the objects are unlimited, the parchment had better be thrown into the fire at once. To another correspondent, Madison complained that, because Hamilton's report broaches a new constitutional doctrine of vast consequence and demanding the serious attention of the public, I consider it myself as subverting the fundamental and characteristic principle of the government, as contrary to the true and fair, as well as the received construction, and as bidding defiance to the sense in which the Constitution is known to have been proposed, advocated, and adopted. If Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one possessing enumerated powers, but an indefinite one subject to particular exceptions. Jefferson plotted against the report using a similar line of argument. In a February 1792 memo prepared for himself, Notes on the Constitutionality of Bounties to Encourage Manufacturing, Jefferson stated that import duties were the principal means of promoting manufactures. Bounties have in some instances been a successful instrument for the introduction of new and useful manufactures, but the use of them has been found almost inseparable from abuse. The power of dispensing them has not been delegated by the Constitution to the general government. It remains with the state governments whose local information renders them competent judges of the particular arts and manufactures for which circumstances have matured them. These notes may have been made in preparation for a meeting that Jefferson had with President Washington later that month. In his account of that meeting, Jefferson attacked the Report on Manufactures, which, under color of giving bounties for the encouragement of particular manufactures, meant to establish the doctrine that the power given by the Constitution to collect taxes to provide for the general welfare of the U.S. permitted Congress to take everything under their management, which they should deem for the public welfare, and which is susceptible of the application of money. According to Jefferson's notes on the meeting, the conversation ended there, without any apparent reaction from Washington. Jefferson's Brit-bashing project went badly awry. Although Congress agreed there was a problem, it decided to fashion a remedy entirely different from that envisioned by the sage of Monticello. On January 11, 1792, the Senate passed and sent to the House a bill entitled An Act for the Encouragement of the Bank and Other Cod Fisheries, and for the Regulation and Government of the Fishermen employed therein. For it was James Madison who stepped into the breach to fashion a compromise that exalted form over substance. Congress did not have power under the Constitution, Madison gravely declared, to grant bounties. This became known as the Bounty Payments to Cod Fisheries Debate of 6th of February, 1792. This was Madison's speech on the floor of the House. In the conflict I feel between my disposition, on one hand, to afford every constitutional encouragement to the fisheries, and my dislike, on the other, of the consequences apprehended from some clauses in the bill, I should have forborne to enter into this discussion, if I had not found that over and above such arguments as appear to be natural and pertinent to the subject, others have been introduced, which are, in my judgment, contrary to the true meaning, and even strike at the characteristic principles of the Constitution. Let me premise, however, to the remarks which I shall briefly offer on the doctrine maintained by these gentlemen, that I make a material distinction in the present case between an allowance as a mere commutation and modification of a drawback, and an allowance in the nature of a real and positive bounty. I feel torn between wanting to support the fisheries within the Constitution and my concerns about the potential negative effects of some parts of the bill. I would have avoided discussing this if it weren't for the fact that, in addition to reasonable arguments, others have been made that, in my opinion, go against the true meaning of the Constitution. Before addressing the arguments made by others, I want to point out that there's a key difference in this case between providing an allowance as a simple adjustment to an existing tax refund and offering a real direct subsidy. I make a distinction also, as a subject of fair consideration at least, between a bounty granted under the particular terms in the Constitution, a power to regulate trade, and one granted under the indefinite terms which have been cited as authority on this occasion. I think, however, that the term bounty is in every point of view improper, as it is here applied, not only because it may be offensive to some, and in the opinion of others, carries a dangerous implication, but also because it does not express the true intention of the bill as avowed and advocated by its patrons themselves. For if, in the allowance, nothing more is proposed than a mere reimbursement of a sum advanced, it is only paying a debt, and when we pay a debt, we ought not to claim the merit of granting a bounty. I also think it's important to distinguish between a subsidy granted under the constitutional power to regulate trade and one granted under the broader, more vague terms that have been used as justification here. However, I believe the term bounty is completely wrong in this context. Not only could it be offensive to some and suggest dangerous ideas to others, but it also doesn't match the true intent of the bill, as explained by its supporters. If the allowance is simply meant to reimburse money that was already spent, it's just paying off a debt, and we shouldn't treat paying a debt as if we're giving a bounty. It is supposed by some gentlemen that Congress have authority not only to grant bounties in the sense here used, merely as a commutation for drawbacks, but even to grant them under a power by virtue of which they may do anything which they may think conducive to the general welfare. This, sir, in my mind, raises the important and fundamental question whether the general terms, which had been cited, are to be considered as a sort of caption or general description of the specified powers, and as having no further meaning and giving no further power than what is found in that specification, or as an abstract and indefinite delegation of power extending to all cases whatever. To all such, at least, as will admit the application of money, which is giving as much latitude as any government could well desire. Some people believe that Congress has the authority not only to grant subsidies as a replacement for drawbacks, but also to give them under a power that allows Congress to do anything it thinks will benefit the general welfare. To me, this raises an important question. Should the broad language used be seen as just a general description of the specific powers granted, with no additional meaning or power beyond what is specifically listed? Or should it be viewed as an open-ended grant of power that covers all cases, as long as money is involved, which would give the government as much power as it could possibly want? I, sir, have always conceived, I believe those who proposed the Constitution conceived, it is still more fully known and more material to observe, those who ratified the Constitution conceived, that this is not an indefinite government deriving its powers from the general terms prefixed to the specified powers, but a limited government tied down to the specified powers, which explain and define the general terms. The gentlemen who contend for a contrary doctrine are surely not aware of the consequences which flow from it, and which they must either admit or give up their doctrine. I have always believed, just as those who proposed the Constitution believed, and more importantly, as those who ratified it believed, that this is not an unlimited government with powers based on broad general terms. Instead, it is a limited government, restricted to the specific powers listed, which clarify and define the general terms. Those who argue the opposite clearly don't realize the consequences of their position, which they must either accept or abandon. It will follow, in the first place, that if the terms be taken in the broad sense they maintain, the particular powers, afterwards so carefully and distinctly enumerated, would be without meaning and must go for nothing. It would be absurd to say, first, that Congress may do what they please, and then, that they may do this or that particular thing. After giving Congress power to raise money and apply it to all purposes which they may pronounce necessary to the general welfare, it would be absurd, to say the least, to superadd a power to raise armies, to provide fleets, etc. In fact, the meaning of the general terms in question must either be sought in the subsequent enumerations which limits and details them, or they convert the government from one limited as hitherto supposed to the enumerated powers into a government without any limits at all. If the broad interpretation of the terms is accepted, it would make the specific powers listed later meaningless. It would be ridiculous to first say that Congress can do anything they want, and then also give them a list of specific things they can do. For example, after giving Congress the power to raise money for any purpose they think is necessary for the general welfare, it would be absurd to add powers like raising armies or building fleets. In short, the meaning of these general terms must be found in the specific powers that follow, or else the government would go from being one with limited powers to one with no limits at all. It is to be recollected that the terms common defense and general welfare, as here used, are not novel terms first introduced into this Constitution. They are terms familiar in their construction and well known to the people of America. They are repeatedly found in the old Articles of Confederation, where, although they are susceptible of as great latitude as can be given them by the context here, it was never supposed or pretended that they conveyed any such powers as is now assigned to them. On the contrary, it was always considered as clear and certain that the old Congress was limited to the enumerated powers, and that the enumeration limited and explained the general terms. I ask the gentlemen themselves whether it ever was supposed or suspected that the old Congress could give away the money of the states in bounties to encourage agriculture or for any other purpose they pleased. If such a power had been possessed by that body, it would have been much less impotent, or have borne a very different character from that universally ascribed to it. It's important to remember that the terms common defense and general welfare are not new to this Constitution. They are familiar terms that were also used in the Articles of Confederation, and even though they could be interpreted broadly, it was never thought that they gave Congress the power they are being given now. In fact, it was always clear that the old Congress was limited to the powers explicitly listed, and those specific powers explained and limited the general terms. I ask the gentlemen themselves, was it ever thought that the old Congress could give away state money and bounties to encourage agriculture or for any other purpose? If that power had existed, the old Congress would have been much stronger, or at least very different from what we generally think of it as being. The novel idea now annexed to those terms, and never before entertained by the friends or enemies of the government, will have a further consequence which cannot have been taken into the view of the gentlemen. Their construction would not only give Congress the complete legislative power I have stated, it would do more. It would supersede all the restrictions understood at present to lie on their power with respect to a judiciary. It would put it in the power of Congress to establish courts throughout the United States, with cognizance of suits between citizen and citizen, and in all cases whatsoever. This, sir, seems to be demonstrable. For if the clause in question really authorizes Congress to do whatever they think fit, provided it be for the general welfare, of which they are to judge, and money can be applied to it, Congress must have power to create and support a judiciary establishment, with a jurisdiction extending to all cases, favorable, in their opinion, to the general welfare, in the same manner as they have power to pass laws and apply money, providing in any other way for the general welfare. The new idea attached to these terms, which no one before, whether for or against the government, ever considered, would have another consequence that the gentlemen likely haven't thought of. Their interpretation wouldn't just give Congress the full legislative power I mentioned earlier. It would go even further. It would remove the current limits on their power in relation to the judiciary. It would allow Congress to establish courts across the U.S. with the authority to hear lawsuits between citizens and in all cases. This, sir, seems clear. If this clause truly gives Congress the power to do anything they think is for the general welfare, and money can be used for it, Congress would also have the power to create and support a judicial system with the authority to handle all cases they believe support the general welfare, just like they can make laws and allocate money for other aspects of the general welfare. I shall be reminded, perhaps, that according to the terms of the Constitution, the judicial power is to extend to certain cases only, not to all cases, but this circumstance can have no effect in the argument, it being presupposed by the gentleman that the specification of certain objects does not limit the import of the general terms. Taking these terms as an abstract and indefinite grant of power, they comprise all the objects of legislative regulation, as well such as fall under the judiciary article in the Constitution, as those falling immediately under the legislative article. And if the partial enumeration of objects in the legislative article does not, as these gentlemen contend, limit the general power, neither will it be limited by the partial enumeration of objects in the judiciary article. I may be reminded that, according to the Constitution, the judicial power only covers certain cases, not all cases. However, this point doesn't change the argument, because the gentlemen assume that the specific cases listed don't limit the meaning of the general terms. If we take these terms as a broad, unlimited grant of power, they would cover all areas of legislation, including those under the judiciary section of the Constitution, as well as those directly under the legislative section. So if the limited list of powers in the legislative section doesn't restrict the general power, then the limited list in the judiciary section wouldn't either. There are consequences, sir, still more extensive, which as they follow clearly from the doctrine combated, must either be admitted or the doctrine must be given up. If Congress can apply money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take the care of religion into their own hands. They may establish teachers in every state, county, and parish, and pay them out of the public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provision for the poor. They may undertake the regulation of all roads other than post roads. In short, everything, from the highest object of state legislation down to the most minute object of police, would be thrown under the power of Congress. For every object I have mentioned would admit the application of money, and might be called, if Congress pleased, provisions for the general welfare. There are even more far-reaching consequences, sir, which clearly follow from the argument I'm opposing. If Congress can use money however they want for the general welfare, and are the only ones to decide what that means, they could take control over religion, hiring religious teachers in every state, county, and parish, and paying them with public funds. They could also take charge of education, setting up schools across the country, provide for the poor, regulate all roads except post roads, and in short, take control of everything from the most important state matters to the smallest local issues. Anything I've mentioned could involve spending money and could be called, if Congress wanted, part of providing for the general welfare. The language held in various discussions of this House is a proof that the doctrine in question was never entertained by this body. Arguments, wherever the subject would permit, have constantly been drawn from the peculiar nature of this government as limited to certain enumerated powers, instead of extending, like other governments, to all cases not particularly excepted. In a very late instance, I mean the debate on the representation bill, it must be remembered that an argument much used, particularly by a gentleman from Massachusetts, against the ratio of 1 for 30,000, was that this government was unlike the state governments, which had an indefinite variety of objects within their power, that it had a small number of objects only to attend to, and therefore that a smaller number of representatives would be sufficient to administer it. The discussions in this House show that the doctrine in question was never considered here. Arguments have consistently pointed out that this government is limited to certain specific powers, unlike other governments that have authority over all matters unless explicitly excluded. For example, in the recent debate over the representation bill, a member from Massachusetts argued that our government is different from state governments, which have a broad range of powers. Our government only deals with a few specific matters, so a smaller number of representatives is enough to manage it. Arguments have been advanced to show that because, in the regulation of trade, indirect and eventual encouragement is given to manufacturers. Therefore, Congress have power to give money in direct bounties, or to grant it in any other way that would answer the same purpose. But surely, sir, there is a great and obvious difference, which it cannot be necessary to enlarge upon. A duty laid on imported implements of husbandry would in its operation be an indirect tax on exported produce. But will anyone say that by virtue of a mere power to lay duties on imports, Congress might go directly to the produce or implements of agriculture or to the articles exported? It is true, duties on exports are expressly prohibited, but if there were no article forbidding them, a power directly to tax exports could never be deduced from a power to tax imports, although such a power might indirectly and incidentally affect exports. Some have argued that because regulating trade indirectly supports manufacturing, Congress should also have the power to give direct financial incentives, like bounties, to achieve the same goal. However, there is a clear difference that doesn't need further explanation. For example, a tax on imported farming tools would indirectly affect the price of exported goods, but no one would argue that the power to tax imports also gives Congress the right to tax agricultural goods or exports directly. Although taxes on exports are specifically prohibited, even without that prohibition, a power to tax exports could never be justified just by the power to tax imports, even if the tax on imports indirectly impacts exports. In short, sir, without going further into the subject, which I should not have here touched on at all, but for the reasons already mentioned, I venture to declare it as my opinion that were the power of Congress to be established in the latitude contended for, it would subvert the very foundation and transmute the very nature of the limited government established by the people of America. And what inferences might be drawn, or what consequences ensue from such a step, it is incumbent on us all well to consider. In short, sir, without going into more detail, which I only felt the need to address for the reasons I've already mentioned, I believe that if Congress were given the power being argued for, it would completely undermine and change the nature of the limited government that the people of America established. We must all carefully consider the potential consequences and implications of such a change. With respect to the question before the House for striking out the clause, it is immaterial whether it be struck out, or so amended as to rest on the avowed principle of a commutation for the drawback. But as a clause has been drawn up by one of my colleagues, in order to be substituted, I shall concur in a vote for striking out, reserving to myself a freedom to be governed in my final vote by the modification which may prevail. Regarding the question about removing the clause, it doesn't matter whether it is completely removed or amended to reflect the principle of a reimbursement for the drawback. However, since one of my colleagues has proposed a new clause to replace it, I will vote to remove it, but I reserve the right to decide how I will vote in the end, depending on the final version of the modification. Summary. Madison's argument in Federalist 41 directly addresses the anti-federalist concerns about the federal government having too much power. He argues that the Constitution's granting of power to the federal government for the general welfare does not create an open-ended, unlimited authority. Instead, these powers are explicitly defined and confined within the specific powers listed in the Constitution. In this passage, the argument revolves around the idea that Congress should not have the unrestricted power to spend money on whatever it deems for the general welfare without clear limitations. This could lead to an overreach, allowing Congress to control all areas of governance, such as religion, education, and public infrastructure, by merely labeling them as part of the general welfare. The principles Madison defends are: 1. Limited government. The federal government is one of limited enumerated powers, not an all-encompassing government that can take control over any issue it deems necessary for the welfare of the country. 2. Power of states versus federal power. Madison emphasizes the importance of the separation between state and federal powers, where the federal government should not take over matters that are best handled by states or individuals. 3. Constitutional authority. The Constitution provides specific, limited powers, and any general terms used in the Constitution, like general welfare, are meant to define and clarify these powers, not to create new, undefined authorities. Madison's defense of the Constitution in Federalist 41 directly counters the anti-federalist fear that the General Welfare Clause could lead to an unlimited federal government by stressing that the powers of Congress are limited to those explicitly granted, and that such broad interpretations of the Constitution would dangerously undermine the government's limited nature. This concludes the 20th class in this series on the Cod Fisheries Debate of 1792. I hope you found the information helpful and entertaining. I will see you in Class 21, where we will go through every article, section, and clause of the United States Constitution. Fall out.